this section of the seminar, we're going to be discussing forfeiture. And when we were preparing for it, they said to me, do forfeiture, they said. There are loads of laughs in forfeiture. Well, there aren't many laughs in forfeiture. It's a well-known maxim that the law abhors a forfeiture, and having spent a good deal of time preparing this seminar, I'm beginning to know how the law feels. Anyway, without further ado, I'm going to deal with a brief summary of the law of forfeiture, and it will be brief, discuss a couple of recent cases, and answer one question that was posed to us. And in doing so, there'll be a whistle-stop tour, which includes transvestites, prostitutes, delayed relief, and the Common Law Procedure Act of 1852. So something for everyone. Those of you who only deal with social housing may be inclined to switch off at this stage, or make a cup of tea, or pour yourself a glass of wine. Although this is a technical area you will need to know about if you're dealing with flexible tenancies or fixed-term secure tenancies, because the case of Croydon and Kalonga is off to the Court of Appeal in December. If you want to know more about that, you can always log on to the Social Housing Law Association website and find out what yours truly had to say about that case during their recently held conference. So, a quick reminder. Long leasehold interests and commercial leases, but we're dealing here with residential long leasehold interests, can be determined by the landlord forfeiting the lease for breach of covenant. In a non-residential lease, this can be affected by peaceable re-entry. If this occurs, the tenant has to apply to the court for relief, and the time limit for doing so is 6 months under Section 210 of the Common Law Procedure Act of 1852. Well worth a read if, like me, you're an old law drafting geek, because it's almost a page long and contains only one full stop. In a residential lease, the landlord must, in rent or service charge cases, serve notice under the Common Hold and Leasehold Reform Act of 2002. Note Section 146, notice is required for rent arrears. There is a rent limit for forfeiture of residential leases. There must be more than £350 worth of arrears. And the arrears must be outstanding for more than 3 years, which gives ample opportunity for the tenant to bring arguments in relation to waiver where subsequent rent demands are met and the like. The principle being that you don't forfeit a valuable interest for a minimal amount of arrears. Under the Common Hold and Leasehold Reform Act, other breaches, that is non-rent and non-service charge breaches, require a determination that there has been a breach of covenant or an admission by the tenant of that breach. So under Section 168 of the Common Hold and Leasehold Reform Act, where the lease is a long lease of a dwelling, no Section 146 notice can be served unless the tenant admits the breach or the question of whether there has been a breach has been determined by the appropriate tribunal or court. So, in effect, you're off to the first tier tribunal for a determination of breach, and then you serve a Section 146 notice as a landlord. There may be other considerations if repairs are the issue, but there simply isn't time to discuss that now. Section 146 of the Law of Property Act 1925 itself provides that the notice must be specifying the particular breach complained of. The notice under Section 146 then must be specific and set out breach in particulars. Relief from forfeiture can be granted by the court, effectively meaning that the lease continues as if it was never forfeit, usually where the breach is rectified, and such relief can be granted on terms. For rent arrears, relief is available as of right, where the arrears and costs are paid into court 5 days prior to the return date. That's under Section 138 of the County Courts Act of 1984. Of course, in the commercial sector, all of this is on hold until New Year's Eve 2020, so far as arrears of rent are concerned, because of the pandemic provisions. And then bear in mind always that the law in this area follows equity. And whilst the law abhors a forfeiture, equity doesn't like it much either. So a proviso for re-entry or forfeiture in the lease must be clear. Allegations of any breach must be clear, because forfeiture is a serious step and it is important to get the technicalities right. So with all of those principles in mind, There are, to discuss, two recent cases of note concerning the specificity of a Section 146 notice. There is a case of Marcatelli and 15 Westgate Terrace Limited, an upper tribunal case, and concerning a delayed application for relief from forfeiture. That is a case of Keshwala and Balsod. That is a High Court decision. Marcatelli concerned a residential flat in Chelsea. The evidence consisted of salacious screenshots of a transvestite prostitute offering services of a sexual nature to men on the internet. There was evidence that older men in suits with young girls were coming and going from the flat. 15 Westgate Terrace, SW10, is technically in Chelsea, perhaps proving that what Charles Dickens said is right, that it was only Cadogan Place that separated the aristocratic pavements of Belgravia from the barbarism of Chelsea. There were two issues in the case. The first was whether there was a sufficiency of evidence of using the premises in breach of covenant for an illegal or immoral act or causing a nuisance. This was dealt with pretty swiftly on appeal. There was evidence of numerous male visitors at night, noise and nuisance, parcel addressed to a transvestite, also offering services on the internet of a sexual nature to men. That may be, you might think, an everyday tale of life in Chelsea. But the circumstantial evidence taken as a whole was, the upper tribunal held, sufficient for the first tier tribunal to find that the premises had been used as a brothel or for illegal or immoral purposes. On the second issue, the appeal succeeded because there had been no proper determination that the leaseholder herself, who had sublet the premises to the transvestite prostitute, had permitted or suffered that use of the flat. Now, permitting or suffering is a common enough phrase in leases and in other legal contexts, but I do rather enjoy it when the law tries to define a perfectly common word in use in the English language. Permit means, according to the upper tribunal, to give leave for something or abstain from taking reasonable steps to prevent the act which it is within your power to prevent. In other words, to permit something. The first tier tribunal simply found that the tenant herself, or the leaseholder herself, had taken few active steps to resolve the situation. That, the upper tribunal said, was insufficiently specific. The whole purpose of section 168, subsection 4 of the Commonhold and Leasehold Reform Act is to establish the facts on which a forfeiture can be based. The determination has to be sufficiently specific to provide a sound basis for a section 146 notice. That is, that no lessee should have any reasonable doubt as to the particular breaches specified. Unless that is done, a county court in later forfeiture proceedings will have an impossible task in deciding whether to forfeit or to grant relief, and would have to hear all the evidence again, contrary to the exact and precise purpose of section 168. Now, this is only an upper tribunal decision, but it is of relevance in other areas. Forfeiture requires strict compliance, but also one can think of injunctions for antisocial behaviour and the like, which commonly have inserted causing, permitting or allowing. So again, for breach of such a term, permitting is key, because with a committal for breach, once again, strict compliance is necessary. So any evidence of any breach needs to focus on the abstinence from taking reasonable steps to prevent such behaviour. The second case we're going to look at is the case of Keshwala and Balsod, and it concerns relief. A relief to know that I'm about halfway through this presentation, but it's a case dealing with delay in applying for relief from forfeiture. Keshwala concerned an application for relief from forfeiture in a case where rent arrears of £500 had accrued because there was a mistake in the tenant's payment. They paid £1,500 instead of the £2,000 due per quarter. The landlord then effected forfeiture by way of peaceable re-entry. The arrears and the next quarter's rent were sent to the landlord's agent, who said they weren't instructed, and then the tenant delayed for just over 5 months in applying for relief. It is a little bit odd that the later demand or invoice for rent was not argued as a waiver, but it wasn't an issue in the case. The judge at first instance refused relief. The delay was lengthy without any explanation. There'd been no reasonable explanation for a delay in 5 months before applying to the court. Now, this decision may have been influenced by the fact that the premises had subsequently been relet, which opens up an enormous can of worms. Hillgate House and Expert Clothing, Brenton Botu, Sheffield City Council Wall number 2, incredibly difficult considerations of concurrent overriding leases and whether granted by deed or not. But we'll just park that for one moment because that's simply my supposition and didn't form any part of the judgment itself. So under the Common Law Procedure Act of 1852, slight mistake in the slides there, which says 1952, I'm only 100 years out, so I hope you'll forgive me for that. But there is a 6-month time limit for relief from ejectment for non-payment of rent. So the granting of relief from forfeiture is an equitable jurisdiction. In law, the statutory time limit is 6 months, and there is no reason why equity should not follow the law. And so on appeal, the court found that if the application for relief had been made before the legal 6-month time limit, any delay within that 6 months was not sufficient to amount to exceptional circumstances for not granting relief. The court must have regard to that time limit in considering all the circumstances, although that time limit may principally be relevant where a claim has been brought more than 6 months after. So if you're before the 6 months, you are likely to have relief granted, whether or not there's an explanation for any delay. If you're after the 6 months, the elasticity of equity in granting relief will depend on all the circumstances, including any delay after the 6-month time limit. So if the delay in applying for relief is more than 6 months, it will not necessarily be fatal if all the relevant circumstances are considered. And in determining what delay is too long, there is a certain elasticity provided to the time limit by equity. So it would seem that Selden was right, that the Lord Chancellor's foot may be longer or shorter, provided it's a minimum of size 6 months. So that's really all I wanted to talk about, those two recent cases on two separate issues concerned with forfeiture. There have been questions posed, and one particular question of relevance to this section of the seminar is whether the right to forfeit arises at the point of breach or at the point of admission or determination of breach. Well, it's a good question, and the lawyer's answer, as ever, it depends. And what follows is simply my humble opinion. But from the context of the question, we're dealing with residential premises. For non-residential premises, the point of breach, the right to forfeit arises. That can be waived or it can be exercised by re-entry, section 146 notice, or the issue of proceedings. But in residential tenancies, for breaches concerning non-payment of rent or service charges, section 167 notice under the Commonhold and Leasehold Reform Act and the regulations thereunder is required. The liability arises on the date specified in the notice, which is 14 days after. For breaches other than rent arrears or service charge arrears, the right to forfeit only arises on admission or final determination under section 168. And that is again 14 days after that final determination. So my reading of section 168, subsections 1 and 2, is that there is no breach until the determination of breach has been made by the first tier tribunal or upper tribunal on appeal, or the county court, who could make a declaration, but are far more likely to transfer the matter to the first tier tribunal for that determination. That concludes this section of the webinar. Thank you very much for watching. And if there's anything further we can deal with, the contact details should be up on your screen now.